Hi, everybody. I'm attorney Michael Ehline, and I'm here with Alan Beck, a really good friend of mine, and he's one of the premier, probably the premier Second Amendment rights attorney in Hawaii, no doubt, and probably, competing for the number one slot in California, in my humble estimation. And he also does a little bit of stuff for First Amendment rights, if your speech or whatever gets messed with by the public schools and stuff like that. He's always been out there to help. And so just to start off really quick, everything that I do here at Ask Michael Ehline, the 10-minute lawyer series, has nothing to do with what I do at Ehline Law Firm. Everything that we're talking about is for a non-commercial purpose. We're trying to help the general public understand things because the mainstream media is such a poor source of information. And how could it be a great source of information when advertisers drive the news? You really can't even be objective, in my opinion. So what I'd like to do is, first of all, no one sponsors me. I don't sponsor anybody. I bring people on who are experts to talk about things. And if you have questions or whatever, you can put them in the comments. And Alan's hopefully going to come back again and we can answer those questions. But so today we're going to talk a little bit about California's concealed carry ban and the crazy battle in the court system. And then we're going to talk a little bit about Alan's expertise of what he's been doing. He's been taking names in Hawaii on behalf of Second Amendment rights people. And then also, just really quick, I'm going to be at the SHOT Show in Las Vegas coming up next week, I think the 22nd. And Dick Heller, a friend of mine and a friend of Alan's for sure, that's Heller versus District of Columbia. I'd really love it if you could come out and show your support for him, because he's been fighting hard on behalf of families to be able to defend themselves against all enemies, foreign and domestic. So Alan, really quick, I just want to give a little bit of background about what happened. So finally, the courts ruled in favor of the Second Amendment and ruled that California's concealed carry issuance was not proper. They had sort of a issue. You had to show good cause before you could carry a concealed firearm. And there was a ban, there's a total ban against open carry. So there was no objective, reasonable way for anybody to carry a firearm publicly if they got attacked or needed to defend themselves in public. And so, Alan, I wanted you to sort of take over and give us the scheme, starting with, we got the law passed, and then all of a sudden, Newsom in California went ahead and said, no, we can't carry anything in a public place. Go for it, Alan.
Thank you, Mike. So, as Michael said, last year the Supreme Court ruled in a case called New York Rifle v. Brune that the chiefs of police have to give you a CCW as long as you're a law-abiding person, and just go through the proper hoops. Basically, they got rid of the good cause requirement that at least some of the coastal cities were made, so you essentially couldn't get a permit in those areas. That has resulted in a national backlash from a number of the gun control groups. So what's happened in California, along with a number of other states, is they've passed what we're calling post-Brune bills. And most of these, well, all these laws that have been passed in various states are very similar. One of the notable components in them is they have something called the default rule, which we also call you might hear is called the vampire rule. And what that is it's a signage requirement. If a private business wants to allow you to carry on their property, the business has put up a sign that says guns allowed. The reality of that is businesses are not going to put up those signs. Firearms policy in this country is a very contentious issue, and people don't want to take a position on something like that and lose clientele. So in reality, the practical effect of this new law, default rule, is that you can't carry in private businesses. And we call that the default rule because historically in this country, there's been a default that you could carry in businesses that were open to the public. And then the burden was on the private business owner to say, no, you can't. And so what California and many other states has done is they're switching the default to one where you can't carry. And that's a ahistorical rule that is undermining many centuries Anglo-American tradition, where they have the default as one you could carry.
And Alan, just for our viewers to know, because you're so advanced, a lot of people don't know that one of the elements that a court is going to look at is the historic significance of how gun laws were in the past, and the right to keep and bear arms historically were through British common law, through American common law.
Yes, that's correct, Mike. And I'll get to a little bit of that framework in a second. In addition, they've banned carry in parks, carry in banks, carry in it's about 15 different locations roughly. And the practical effect of what California has done, along with a host of other states, is you essentially only can carry, in your car and on the sidewalk without, simply because these laws are so onerous. And that's the case in Maryland, New Jersey, and New York, Hawaii, where I practice, as well as in California, and then in California law. And there's a few other states that have passed somewhat less onerous laws that mirror this, but to a lesser degree. So the Supreme Court said last year that what you need to do, as Mike was saying, is in order to justify a gun control law, you have to look to what the framers of our country at 1791 thought was constitutional. And you do that by seeing whether they had laws on the books that prohibited carry at a certain location. And, well, I've done this research, and guess what? We do not have a historical tradition of banning carry in parks. And by parks, I mean literally the middle of the woods. We have some very large state parks in this state. And, I can't say how much the state is being prohibited, but I would guess it's upwards of 90%. Now, that doesn't make a lot of sense. The Supreme Court last year said you have a right to carry a handgun. And yet the state of California is saying, the vast majority of the state, you can't carry. That just doesn't jive with what the history of this country is, and that doesn't jive with what the Supreme Court said.
And Alan, it also sounds absurd, like it might violate the absurdity canon.
Yeah, I mean, it's what California and many other states is doing is they are trying to justify this based upon a science what the Supreme Court wrote both last year and a 2008 case called Heller v. District of Columbia. And there, the Supreme Court did say that you can prohibit carry at certain sensitive places. It also made it very clear that sensitive places are the exception. So, sure, I mean, maybe you've got, some government facility that's just a really important reason in that particular government facility. For example, the Supreme Court alluded to the fact that courthouses are probably a sensitive place. That's the word they use for where you can't carry. Well, a courthouse is a lot different than, say, 10 miles into the back country of a state park. There's a judicial proceeding going on. And real important, it's also really importantly is the government has taken over the security in those locations. You have to pass through a metal detector, and there's armed security that will protect you if a criminal decides to assault you. Now, that's a far cry. I'm just going to keep harping on the fact that it's illegal to carry a gun in the middle of the woods when you're alone, miles away from anyone. And the fact that California is using this rationale to try and justify carrying in and call, the middle of the wilderness a sensitive place